Before we proceed on the motion, the court does not appreciate you telling court staff to shut up. This is the defendant's motion regarding parenting time. And I believe, did we not adjourn this one because some party was going to get counsel?
Yeah, that is correct, Your Honor. Counsel was, the adjournment was sought the last hearing for, I believe, the counsel.
All right. Ms. McIntosh, is your attorney here?
No, he could not make it today. So I'm not asking for another arraignment. We've discussed it. I've gone through the hearing with them. I am confident in what I'm going to do today.
Okay. All right, so we'll proceed. Off the record just a moment ago, Ms. McIntosh made a statement, and it was not, as I stated, not on the record, so I need to hear from Ms. McIntosh. Place on the record, well, let me place you both under oath first. Would you both please raise your right hands?
Are we going to
Accept, I accept, yes.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. And I have witnesses outside, Your Honor.
I'm sorry, I didn't hear your
Yes.
end. Okay. All right, go ahead though. What do you want to tell the?
That Mr. Ludington threatened my boyfriend, Michael, outside because I did not agree to the custody that he wanted, that he would put him in jail today.
Who would put who in jail?
That Mr. Ludington would put Michael in jail today.
Okay. Did you report it to police?
It just happened today, Your Honor. I was waiting for my turn because I was taught you do not interrupt the court when they're in other court proceedings.
Oh, no, you could walk out of the courtroom and contact police at any time if you believe there's a violation of any criminal law. I didn't hear it, I didn't see it. I'm not here to question it, but if there is an issue relative to that, contact the authorities.
Okay.
Sure. Okay? So you may be seated. You're
Yes,
fine.
sir.
So we are proceeding.
And again, Your Honor, my witnesses are outside. Can I go get, not like outside, but just outside the courtroom? May I bring them in?
Well, wait, just a moment. Let's address the motion first.
Okay.
Let's address the motion first. We'll see how we proceed in that regard moving forward. Mr. Ludington, why are you requesting parenting time being changed?
Why am I? Because she has not a stable home. She bound in the last year, she's had over 4 different addresses on court records so that I can show. She takes the children, allows them to be around people that are convicted of criminal sexual conduct, 4th degree, between which under the law, it's 13 to 15 years old, which she allows my daughter to be left in the care of this person, in which I have an
What's the
order.
person's name?
His name is Michael David Sims.
Is that the individual that's outside?
Yes.
Yes, Your Honor. Oh, my bad.
So, Mr. Sims, you heard the allegation here just a second ago. What's your position as to what happened?
I'm not Mr. Sims.
I'm sorry, I'm looking at the wrong file. Mr. Ludington. Mr. Ludington, give me your account of what you believe happened in the hallway.
In the hallway, I got the court order for a personal protection order, which I'm gonna file asking you to do. That's what he's gonna go to jail for if he violates, because I'm asking the court to instate it. Because he has no business to be around my 4-year-old. Being a criminal, sexual predator that coerced a 13-year-old and trying to have sexual. It's in the paperwork. It's on his MDOC. There's no denying. That's what I'm asking.
So
She won't protect my child.
threaten?
No, I didn't. I told her what I had a paperwork. I'm getting filled out. If he doesn't comply with it, he could go to jail. That's what would happen. He would go to jail.
If the court grants it.
Yes, that's exactly, sir.
Okay, so you're alleging, and we'll get your response.
Mhm.
No stable home,
No,
according to you, 4 different addresses within a year. Takes the kids around sexual predators or offenders.
Yep.
Specifically, Mr. Sims, your daughter is being watched by Mr. Sims alone. That's your
Yep.
allegation. Anything else?
no, that'll be it.
And is it week to week?
It's supposed to be week on, week off.
How old is the child?
She'll be 4 the 11th.
Is a child in preschool or?
No, because she won't allow me to get her vaccinated because she won't give me a social security card or nothing, which I'm in the process of getting, so I can get her into school. Her other children are not in school either. I want my child to have an education, Your Honor, and it's becoming a battle, and I want to protect her, and I just don't, I'm asking the court, because this is not the first time I've had to come to the court to even get my child back on the week on, week off, when she would take off to wherever and not bring the child, tell me where the child was so I could come pick her up.
Now, if I recall correctly in your motion, you had stated, and tell me if I'm wrong,
Yes, sir.
that you went to the home where you believe the Ms. McIntosh wanted
Yep.
to pick up the child, but then you found out that a week prior they had moved.
No, I didn't find out till that night they moved.
Right.
Yes.
You
With
found out
Sergeant
that,
Woodruff. Yes,
found out that they moved out a week prior. Now,
Yes.
you didn't find out a week prior. You found out that day that.
yes, sir. Yes, sir.
Okay. And where was that home originally?
665, I believe it is.
Here in
Van
Huron.
Dyke right here. And
FedEx.
FedEx, yes.
Okay. And tell me about this vaccination issue.
I'm trying to, she, for some reason, will not vaccinate none of her children. I want mine vaccinated, like I got a 15-month-old in the house too, daughter, and she is vaccinated with everything that's going on with the measles and everything. Your child, and we can't even get them into, you can't even put your child on online K-12 without vaccinations. And she just fighting me every step of the way, won't give me so she gets WIC for the child and still will not have the child vaccinated.
And both parties, you both have joint legal custody.
Yes,
equal
Your Honor.
decision-making power. Okay. Are you exercising the week on, week off currently?
No, I've had her for the last
Okay.
6 weeks, I
What I
believe.
thought. I just want to make sure.
Yes, sir.
Okay. Anything else you want the court to consider before I go to Ms. McIntosh?
No, sir.
Okay, Ms. McIntosh, go ahead.
Okay, so the issue with Michael, Earl has known Michael is a sex offender from the day that me and Michael decided to get together. Me and Michael are not just boyfriend and girlfriend. I have 3 other children by Michael that are Rebecca's siblings. He has never been left alone with Rebecca because we live with other people. And I ask Emma or Jason to keep an eye on Rebecca. So I don't understand. And my other father of my children don't have an issue with Michael being a sex offender either. And now all of a sudden Earl wants to bring it up to the court's attention because I'm not giving him what he wants. And for
What do you
the-
believe you want?
He wants full legal custody of my daughter and he's not getting it. And for the immunizations, Your Honor, I have 2 copies, 1 copy for you, 1 copy for me of my daughter Rebecca for her to go to school. And I've already talked to the school. I can get her enrolled today as soon as I get custody back of her. So Earl can have her every weekend from Friday to Sunday. They said that I can enroll her as long as I have the immunization waiver. Earl is not even on her birth certificate. So I don't understand why he's trying to enroll her into school. And I've already, and I have,
He has joint legal custody,
yes, Your Honor,
so he has the authority.
but I have shot waivers for every one of my children and all of my children are in school besides Rebecca and Samus because Samus is 6 months old.
Public school?
Yes, Roy is in the ISD school. Phoenix is in the early on. Monica and Joshua are in Cleveland Elementary School.
You said the ISD, you pointed over here.
Yep, Roy's here with his dad in the ISD here in Bad Axe with Phoenix. Phoenix is with her dad, Michael. They go here in Bad Axe. Samus will be going as soon as she hits 1.
Okay, I got it. I think I understand.
So, and I don't understand why he has to fight me. When I tell him no vaccinations, that means no vaccinations. None of my children have vaccinations. And I have the waivers to prove that she can be into school without it.
All right.
And Your Honor, he also stated that I do not have a vehicle. And I have my application for my Tahoe that I had previous, and then I have a Durango right now in my name. So I do have a vehicle. And the registered sex offender that he complained about in the 2 registered sex offenders in the trailer park where I live with my daughter Rebecca, I have the application for the trailer park. It asks you if you are a sex offender. I did not know there were sex offenders that were in the park when me and my child moved in, because I was asked if we had any felonies, sex offenders, or any traffic violations, because this is federal housing. So I don't understand how those sex offenders got in there, but I have contacted the management and I have requested the removal of those sex offenders in the trailer park.
Removing the individuals from the.
Yes, because it is a federal housing. They're not supposed to be there. So that's what, and so I have contacted the management and requested for them to be removed out of the trailer park. And Michael is not living in the trailer park with me and Rebecca. He lives here in Bad Axe with Roy, Phoenix, and Samus, his children. But I have sole legal custody of all of my children but Rebecca. Sole legal and sole physical custody.
And that could explain the difference why the other children can be around a sex offender when you have joint legal custody and father saying he doesn't want that.
Right.
You may be seeing.
Yes, sir.
This is what the court is going to do. This is a motion regarding parenting time. What I'm hearing, and I acknowledge, the court acknowledges here that this is really more than parenting time. This is custody. Not only physical custody, but legal custody. The parties currently have joint legal custody. I believe mother would have physical. No, I'm sorry, joint physical. They go week on week off, we're supposed to.
He has physical because when we started this, Your Honor, I had a medical condition when I was pregnant with Samus. I had a cyst and it was growing and I did not.
I get it. I don't want to hear from the president.
There was a judgment order affiliation and support that entered on March 7th, 2024. That order was stipulated to grant both joint legal and joint physical custody. Real time on a weekly basis.
Okay. I failed to ask this, Ms. McIntosh, but you were living in the Bad Axe area
Yes, Your Honor.
and you moved to Port Huron area.
Yes, Your Honor. And he knew I've been looking for a place to live.
I just
since-
asked the question.
Oh, sorry. Go ahead.
I would just answer my question. And you understand that if you have joint legal and joint physical custody and you're living in Port Huron and father's living in Huron County,
Father's living in Tuscola.
well, Tuscola, Huron doesn't make a difference,
Sorry, Your Honor.
but what it comes down to is when the child starts school, the child can't go to Port Huron schools on week 1 and then to a Tuscola County school on week 2.
Yes, Your Honor. That's why I want my physical custody and he can have her every weekend. Like every weekend. I will even do all the transportation and drop her off and pick her up. He can have her every weekend.
All right, well, this is originally a motion for parenting time. The court finds that this is really a motion for custody. Court finds that there is a change in circumstance that would warrant the court to review review the custody factors, in this case, the best interest factors. The change in circumstance is the moving of Ms. McIntosh to Port Huron, the acknowledgement of Mr. Sims being involved, having a relationship with the plaintiff. Mr. Sims, according to both parties, is on the sex offender registry, which is a concern of the court. And as a result, I find a change in circumstance which would warrant a review of both physical and legal custody. The court is address the physical custody because also we have the issue of where the child will be going to school in the fall. Number 2, regarding legal custody, there's an issue between the parents relative to vaccinations. And the court's position and the law is relative to disputes regarding legal custody is that if the parties disagree on significant or very important issues pertaining to the child, whether it be education, even religion, and medical issues, this being a medical issue regarding vaccination, that there is certainly that factor that needs to be considered by the court. And when those situations arise and the parties cannot agree, there is a very good possibility that only one parent will get legal custody. So the idea here is for the parties to attempt to agree to the best extent they can in the best interest of the child, how to move forward. If the parties cannot agree, then a legal custody motion, which the court now finds in this matter, will be addressed. And with the front of the court investigation, they will make the recommendation to the court and to the parties as to what they believe is in the best interest of the minor child. When that report is prepared, either party can agree with it. If they disagree with it, to file the proper paperwork to say they disagree and why they disagree. And then we have a hearing to address custody, parenting time, as well as physical and legal custody, and also support. Because if the custody order is modified and one party has more time over the other, then the support issue needs to be reevaluated as well. So that's what I'm going to order. In the meantime, at this point, I'm going to continue prior orders regarding the parenting time. Actually, Dad, what's your position on that? Do you wish to?
I want to keep her till the next court date until.
Well, that's going to take some time. And
I
I don't
mean,
want to.
I'll let her come visit, whatever, but I'm not letting her go. I shouldn't have to allow her to take her and not bring her back. I mean, I got her in my custody. Why should I have to let her go
So
and not
last
get her
time it's
back?
my custody,
Miss,
miss my time.
That's what I'm asking the
Sorry.
court, because this happened before.
I
when
have
she
missed
took
my
her
time
and then
with my
wouldn't bring her
daughter
back.
already. I would like it to go back to the way it was, week on, week
No.
off.
Court's not going to do that because
Thank
there's
you.
an issue regarding Mr. Sims.
Thank you.
He's not living with us, so I'm living in Port Huron. So I don't understand why Mr. Sims is the issue. He stays here in Bad Axe with his 3 children, and me and Rebecca, Joshua and Monica are in Port Huron.
I will allow on an interim basis, parenting time, 8 hours every other weekend. Mr. Sims is off limits. Completely off limits. Anyone on the sex registry is off limits. The 8 hours can either be Saturday or Sunday.
So does that mean his best friend can't be around her either because he's a registered sex
I don't
offender?
have nobody around him.
Brian is a registered.
Hold
sex
on,
offender.
Miss, I've had enough.
Thank you, Your Honor.
I've had enough, please. There's
I'm just
proper,
trying to understand my position here, so.
well, let me
Michael's not-
finish. Let me
Okay.
finish. And then if you have a question, because if you've noticed, in previous hearings, I've asked, do you have any questions? That's the proper way of doing it. Interrupting the court is not the way to do it.
Yes, Your Honor.
Thank you. 8 hours, Saturday or Sunday. And both parties have transportation. Dad, is it easier for you every other Saturday or Sunday for 8 hours to bring the child over or to pick up the child?
I can do either. I have.
Either? Okay, how about you, miss?
Either, doesn't matter. Your Honor.
Okay.
I
Well,
mean,
court will follow its policy that when you want the child, you pick up the child. And when you return the child, the party that is to receive the child picks up the child. So Ms. McIntosh, you will go to Mr. Ludington's or a mutually agreed location to pick the child up, either Saturday or Sunday. We need to figure out which day and what the hours will be. And then at the conclusion of that day, Mr. Ludington, you will receive the child and take the child back to your residence. That'll be every other Saturday. Can we begin it this Saturday? Both parties are nodding. What time on either Saturday or Sunday? Which day is better for you, miss? Saturday or Sunday?
Whenever day I can pick my
I
daughter.
have a question. We do it Sunday? Because I have a birthday party while she does for her
either
9-year-old
day.
friend Saturday.
She said either day.
So if we can do Sunday, great. She
What-
got a birthday party Saturday, but hey, if she, it is what it is.
What times do you prefer for the 8 hours?
You mean from noon to 8?
Want noon to 8?
Yep.
Sir,
That's fine.
noon to 8. This Sunday, noon to 8. What will happen is Ms. McIntosh will pick up the child at noon. Mr. Ludington will pick up the child back. Well, hold on here. It's only 8 hours.
Your Honor, if
I'm assuming you'd be staying in the Port Huron area the 8 hours? Or would you head back?
I got somewhere in Yale. around there, K-Pac area. I can,
So you
I'll
can
make
do
it
the
work.
transportation.
yeah, I'll make it work.
Okay. So he'll do the transportation then. The court changed its ruling then.
What address do I take her to?
Address, please.
4125,
The Dub Road?
yep,
Okay. And then I pick her, oh,
lot 37, Your Honor.
37?
and then I pick her back up at 8 o'clock on Sunday night.
And that will continue as an interim order until we have the custody, parenting time, legal physical support report or recommendation. This Sunday.
Mr. Luddington doing all transportation or only transportation for this weekend?
Let's switch it off. I mean, she wants to do it. She can come pick her up and
We'll
I'll,
alternate the transportation.
yeah,
You okay with that? So this Sunday,
I do it all.
you do the transportation all. Next week, or the 2 weeks after that, you do the transportation all.
Yep.
That's how we'll do it.
Yeah.
If, I know the parties had agreed for parenting time this coming Sunday, if they can't agree, is the default period Sunday from noon to 8?
Yes. Yes. So if you agree on another time, mutually agree, that's fine. Court has no problem with that. But if you don't agree, it's noon to 8 every other Sunday, beginning with this Sunday. Questions? Yes.
Yes, Your Honor. So now that it's stipulated that Michael's not supposed to be around her, but his best friend Brian is also a sex offender, is he not supposed to be around her either?
You have to file a motion for that.
Okay, and then
File a
another,
motion.
one more question, Your Honor.
Go
Can we
ahead.
can we transfer this to St. Clair County, because that's where I live?
You have to, well, you've lived there how long now?
Since January.
All right, file a motion. You have to file a motion for that as well.
I have to file for motion that for as well.
Yes.
Thank you, Your Honor.
Any other questions?
No, Your Honor, I'm so sorry for interrupting.
Appreciate it. Thank you. Do you have any questions?
Nope.
Let's see how this goes. Good luck to both of you.
Thank you.
Off the record. Oh, yes, both parties, would you stop by the front of the court's office to pick up your packets? These are packets that you need to prepare for the front of the court to do their investigation. Regarding alleged contempt proceedings against Ms. Mausoff filed by Mr. Talaski, the parties are present. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, thank you. Before we proceed in this matter, again, I'm just cautioning both parties, please don't mention the child's name. Initials are appropriate, but please don't mention the child's name. And let's hear from the friend of the court. Mr. Holdwick.
Your Honor, currently the parties share joint legal, joint physical custody. My understanding is that the defendant has alternating weekends of parenting time during the school year from Wednesdays after school, or 3 if there is no school, until Monday morning when school begins, or 10 o'clock if there is no school. The front of the court had received, I guess let me back up here. The front of the court office on January 17th received a phone call from Ms. Mausoff informing that she would pick the minor child up from school. There have been some issues of the child going to Mr. Talaski's. She was informed by the front of the court office that any violation of the court order could result in enforcement if we were to receive a written complaint for denied parenting time, and that we must enforce the court order as it's currently written. She stated that she did understand that there were safety concerns or well-being, she could contact protective services. Also, upon that conversation with the front of the court office, she was emailed a parenting time motion, fee waiver, and filing instructions. And if she wished to file a motion, the court, she could do so. As stated, that was on January 17th. After that phone call at the front of the court office, the front of the court office did receive 2 denied parenting time complaints from Mr. Talaski, dated January 30th was one. Both of them were January 30th for 2 separate weekends. So the show cause was scheduled for an alleged violation of denied parenting time for the weekends of January 17th and January 30th, as well as not communicating an emergency with Mr. Talaski involving the child.
Okay, before you have a seat, Mr. Holdwick. So when this phone call was received on January 17th, are you stating that Ms. Mausoff stated that she was taking the child? or picking up the child?
My understanding is that she had concerns sending the child for parenting time. She picked the child up from school.
And that's presuming obviously it was dad's time on the 17th.
I would, based off of the complaint, that's what I would guess as well, or assume as well, based off of the order and the complaint.
Have you heard anything from Child Protective Services or anything relative to any safety concerns?
Review this, Your Honor. I'm not aware of any protective services involvement. Yeah, and Ms. Schultz is confirming that we're not aware that we've received any requests for information from
All
protective
right,
services.
and the reason I asked the question, and either you or Ms. Schultz can correct me, but if there's some serious emergency issue regarding a child going to another parent and Child Protective Services gets involved, isn't it true that on when you have significant matters like that, most times Child Protective Services will contact the front of the court office?
They will contact the front of the court office. Any investigation, they'll contact us.
Any
requesting
Okay,
what court orders exist or copies of them. Serious inquiries, they will contact us and speak with one of us to state concerns or maybe an interim arrangement, safety plan, things of that nature. Does not change the court order if a written complaint is brought based off of that, but they do contact us if there are significant issues.
and as you stated, there's been no contact.
To our knowledge, we've not been contacted. Correct.
Either situation, if they're looking for parenting time orders or for
Correct.
emergency.
Correct.
Okay, thank you. Plaskett, what's going on here, sir?
On January 17th, Your Honor, there was a tournament, a hockey tournament. And it was in Notre Dame, Indiana. The Cherish had asked me on January 5th if Ethan could be registered to go, and I did tell her that we had plans, or I had a birthday party planned for my younger son, T, and that he would not be going. She's harassed me about letting E go and putting E in the middle, having him call me, try to negotiate something with me. But I was adamant that we had a birthday party planned for T and that wasn't possible.
And that was your time, correct?
Yes, sir.
And correct me if I'm wrong, but didn't we address this hockey issue before?
Yes, sir, Your Honor.
And I know it may sound cold to individuals who may not have to deal with custody or parenting time orders. A child may have an interest in a particular field. It could be 4-H, it could be farming, it could be a job, it could be sports, it could be anything like that. But when the child's with the other parent during that parent's either custodial or parenting time, that parent controls what happens.
Yes, sir, Your Honor.
And that's what you're relying upon here, correct?
Yes, sir.
So you're alleging not only, did you see the child at all on the weekend of the 17th?
I did have him the 15th and 16th. And then when I went to pick him up,
Were you supposed to have him the 15th and 16th?
yes, sir, Your Honor.
Okay. Oh, pick him up from school.
Yes, sir.
And did you see the child the weekend you're supposed to have the child?
No, sir, Your Honor. I had T, but not E.
Okay. What about the 30th?
The 30th, I supplied the school with the divorce decree and then highlighted all my days. And E was supposed to go to the office because I was afraid of this happening again. But when I went to the school to get E on the 30th, he had gone out the back of the school. And then Cherish had taken custody of him then.
So you're saying that the child was with mother that weekend as well?
Well, that Wednesday, On the 30th, E was with her. I did, however, pick T up. And then on the 31st, I had my daughter pick E up 15 minutes prior to him being dismissed. So that couldn't happen again because she had planned on taking E on the 31st too.
31st would have been a Thursday or Friday?
Thursday, I believe, Your Honor.
Friday. Okay, so for the second weekend, you're not alleging that you missed the whole weekend. How many days did you claim?
1 day, Your Honor.
1 day. I saw Mr. Holbrook spring up all of a sudden.
Yeah, just for the record, Your Honor, looking at the complaints and looking at the calendar, regarding child E, between the 2 weekends, I believe it's a total of 4 overnight.
Total of 4? Okay, anything else you want to tell me before I go to?
No, sir, Your Honor.
Okay, thank you. All right, so Ms. Mousoff, how do you respond to this?
Contrary to the allegations that Brian is making, my actions have always been for the best interest of both children. The last time we were in court was October 4th, and I explained to everybody then that Ethan's mental health, he was not in a good, he was not in a good place. Emotional breakdowns, he started doing poorly in school. And from October to January, it had gotten worse. He talked about hurting himself, feeling trapped when he was at his dad's, not wanting to live anymore.
So with that in mind, if that is true, then why did you not file a motion for change of custody and or parenting time?
Well, I tried therapy first. And when I tried to talk to Brian about it, and I didn't get anywhere then. And so as far as that weekend goes, on Monday, Ethan took it upon himself to call Brian, and
We're not going to go on what the child.
okay,
I'm talking about your actions.
okay,
Let's just talk about your actions.
okay,
So you're alleging mental health concerns.
yes,
Okay. So the proper way of doing that is to file a motion with the court and not defy court orders. You defied a court order. What's attached to this is the app close information, which indicates E called me from, this is from you, E called me from school, pleaded for me to pick him up. He begged you to let him go, referring to this hockey tournament. So, and then you put in mental health part here, but it was his dad's time though, right?
which has since been made up. That weekend was made up.
That's not true, Your Honor.
It is true.
Whoa, wait a second. Wait a second. We'll address that in a moment. We'll address it in a moment. But you read, Miss, the notice that lists the possible consequences for violation of court orders?
On that day, I was stuck.
No, I'm asking you, when you received your notice from the friend of the court's office regarding today's show cause, did you review that?
I did.
Okay. And did you review the possible consequences if you're found in contempt?
I did.
Okay. Well, I'm finding you in contempt because a couple things. Number one, the court order clearly establishes what the parenting time, custodial time schedule is. That's one. Number two, when it comes to serious issues, and you know, I'm always going to have one parent say, well, there's a serious mental health issue. The other one's going to say, no, that's not the case. That's what I'm presuming here. There's nothing from a psychologist, psychiatrist, counselor, therapist to indicate that there's an issue. I'm not doubting you, but I don't know that yet unless I have information from the horse's mouth, so to speak, regarding that. And as a result, I find you in contempt for failing to follow the court order on those weekends. I may add as well, by calling the friend of the court, telling them that you were going to do this clearly shows that you had the intent to do this early on. And I find bad faith as a result of that as well. Is there anything you'd like to say before the court imposes disposition on this?
Yes, that week he started having panic attacks at school. I had to go pick him up Tuesday, the 14th, to go get him from school. He's having chest pain, shortness of breath. He did not want to go to his dad's. I got a text message from the school counselor that day. She was checking in on him because he has been seeing her regularly.
Okay, this has nothing to do with, is there anything you'd like the court?
This is why I made my decision on Friday to pick him up.
Why, I understand that, but you did this on bad faith, as far as the court's concerned. And as a result of that, the proper method is if there's a mental health concern, file a motion with the court. Ask the court to suspend parenting time, for instance. That's not been done. You just did it upon yourself. And that's not proper. A moment. Court is going to order a sanction in the amount of $250 payable to the friend of the court, as this was done in bad faith. The proper method, again, is to file the motion. When you take the law into your own hands, there are consequences for that. Now, you're claiming that the 4 days have already been made up?
The 3, the
Well,
kids,
according to the friend of the court, it'd be 4 overnights.
they spent an overnight December 20th, February 8th, and February 9th.
What dates again?
December 20th, February 8th, and February 9th.
Just a moment.
Your Honor,
Yes,
those are the dates. I don't believe the December one would necessarily count.
it doesn't.
After the fact.
It doesn't.
But the other 2 dates, if those indeed were made up, that would be 2. So my calculations, I'm getting 3 overnights for the weekend of January 17th. And then I'm getting 1 overnight for the overnight of January 30th.
That's where I'm getting it to. Okay, so Miss, February 8th and February 9th, were those your times?
Yes.
Okay. Do you have any documentation or anything to indicate that you had this sort of agreement with Mr. Tulaski?
Just our conversations on app close.
Okay. So you have them with you?
I don't know if I have the conversations from that particular weekend.
When do you claim you made this arrangement?
So the tournament weekend would have been the 17th, so it was right after that. He would have had them the following weekend. And then he had them both weekends in February, the first 2 weekends in February.
Okay, well, I have. So are you saying you did this on the 17th? Had the conversation on the 17th?
We had a conversation the week prior to the 17th. He said that Ethan E. could go that weekend if I gave him every other week in February, because the children are often used as bargaining chips. And
Okay, well, I want to
yes,
get to,
and so
I just want to get
that
to your.
didn't work. That didn't work for me, giving up every other week.
Oh,
So
all right,
then
Miss, you're,
after the 17th.
excuse me,
Yes.
please, you're getting off the beaten path here. I'm trying to figure out when you had conversation with Mr. Tulaski about February 8th and 9th.
It would have been right after that weekend then, because the first suggestion didn't work for me.
I don't see that nap close, but it may not have been provided to begin with. Sir, did you have the child on February 8th and February 9th?
Yes, sir, Your Honor. But that was to enable her to take Ethan to a tournament the following week on my weekend. So she provided me both E and T on her weekend. Yes, sir.
So did you have your weekend the next weekend?
I still had my weekend. T went with her to a tournament and no, excuse me.
Tournament.
Right. E went with her to a tournament on my weekend and
So you lost that whole weekend.
just with T. Or just with E, I'm sorry.
That makes more sense.
Okay. But that had nothing to do with the dates in question.
May
Yes, please.
looking at the calendar, Your Honor, what I'm hearing is that the parties agreed to switch the weekend of February 7th and 8th for the weekend of February 14th and 15th.
Yes.
Court finds it's not been made up. 4 overnights will be ordered within the next 6 months, according to the friend of the court policy. Now, before we move on from this, and by the way, that $250 needs to be paid by April 4th. Before we leave, first, I'm glad to hear no one was injured in the traffic crash, according to my review of the file. But I want to make sure this is not on the screen. Sir, can you see that?
Yes, sir, Your Honor.
Who's in the picture?
That would be my son, T.
Is that a proper way to restrain the child?
No, sir, Your Honor.
Don't let it happen again.
Could I explain myself, Your Honor?
No, I just said, please don't let it happen again.
Okay.
That's it. It appears to be on a roadway. There's brake lights on.
It is pulling out of the parking lot at the school. And she did send me that picture, and I did send her the explanation behind it. And he was, before we reached 53, back in his seatbelt.
He needs
Your
to be
Honor.
in the seatbelt anytime the vehicle's moving.
He does from time to time like to slip out of them, as all kids. And my saying when I put the boys in the vehicle is buckle up, Chuck. So they do tend to want to holler out the window at their friends, but I will put a stop to that.
Thank you. Lock the back window so it doesn't open.
It is, Your Honor.
Child needs to be restrained. I don't want to see that happen again.
Okay.
Best interest of your children. That'll be all. Thank you.
Can I say something, Your Honor?
Yes.
In regards to his second motion that he filed for the 29th, I had gotten a phone call from CPS on
Wait, what second motion are you referring to?
when I picked E up from school on the 29th. He says it was the 30th, but it was the 29th.
It's not a second motion, just the second motion.
Oh, the second weekend?
It was the one night. I had gotten a phone call on the 24th from CPS saying that there was an open investigation against Brian. And I met with them on the 28th, and they told me what the allegations were. And part of the safety plan was to keep doing what I was doing and just.
Okay, but where is the CPS worker to testify to that? You have to have the CPS worker
Okay.
here. That's hearsay. That's,
Okay,
if there's a safety issue, bring your witnesses with you.
okay.
You have to, because otherwise it's hearsay and the court can't hear it. Just like if the child says, I don't want to go to dad's or I don't want to go to
No.
mom's.
I was just abiding by what we discussed when I picked them up on the 29th.
Okay, but that's your position on it. I have to hear it from the horse's mouth.
I know her report was not going to be done by today. So,
Okay. We'll continue to follow up with it. And if there's any issue, the court will probably see that down the road then. Good luck.
Your Honor, I did file a motion with friend of the court about her not reporting to me that Ethan was in a car accident.
That was also attached to today's.
Okay, I did see that. I did see that. Did the child have to be hospitalized?
no,
Do you think it'd be a good idea in the future, if there's an issue regarding the child, to keep dad or vice versa, to keep you in the loop?
We need to work on our communication issues because anything that is said to Mr. Tlaski is twisted around and used against me.
Well, I'm not here to judge that at this point,
Mhm.
but what I'm here to consider is if there's any issue with the child that's of any significance.
There's no issue.
Please hear me out.
Mhm.
If there's any significant issue regarding the child, and I did see the photograph of what appears to be a bruise due to a seatbelt. Thank God, there's another example of why seatbelts are so important for young folks like that. If the shoe were on the other foot, as a parent, I would feel very concerned as well. So if there's anything significant regarding the children in any way, shape, or form, it takes 2 seconds to get on app close and say, this is what happened. Because take it, just for instance, and hypothetically speaking, not each of you, but if I and my bride had a child in common, ex-bride, in my example, though I'm not divorced, but I get the child back and I see a huge bruise on the backside, front side of the child, wherever the bruise may be, and I haven't heard from the parent, the other parent who had the child during that time frame, I'd be extremely concerned. And so you're right, the parties have to communicate better. And that's why app close is so important. It just takes 2 seconds. We were involved in a traffic crash. There will be a bruise on him due to the traffic crash because of the seatbelt. No medical treatment was sought. He's fine. He was evaluated, whatever the case may be. And then there's no arguing about it because you let him know. Vice versa, you would let her know in the same situation.
Absolutely.
So that's how I treat that motion. You have to communicate. And it doesn't need to be twisted, turned around against anyone. It's the best interest of these children. That's what it comes down to. We're done on this issue. Good luck to plaintiff's motion regarding parenting time and custody. We called this case earlier this morning. Ms. Gage was present. She's the moving party. The court called Mr. Hockmuth. It was, I can't remember what time I called the matter, but it was during the time frame here between 9 and 10:30. It's 10:34 now. The defendant is not present. He is not checked in to the Zoom application as well. There's a certificate of mailing in the file. The certificate of mailing is executed by Alicia Thomas, Family Court Clerk, Huron County Clerk's Office, February 5, 2025, to Mr. Hockmuth at an Owendale address. And he has failed to appear. And as a result of that, at this point, as proper notice has been received or been provided to the defendant, we are going to proceed without him being here. Ms. Gage, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Please state your name for the record.
Angel Gage?
Ms. Gage, I read your motion. This is regarding custody and parenting time, correct?
Yes.
What is the current arrangement right now?
We found it off.
All right. And in your motion, you're alleging that that has not been working. What's been going on?
Mr. Hockmuth is on second shift currently. And he is left home every night from the time she gets out of school until he returns home, sometimes as late as 1 a.m. if he has to work overtime. And he has also been working the weekends, so she is home at night on the weekends as well.
How old is the child?
11. I do the best I can when I can to go check on her to make sure she is safe, because she does not have a phone, because she proved herself unable to have the internet. So I have taken the phone away.
Children can be children.
Yes. She is not allowed to lock the door to even to protect herself. When I have left his house, because he has no problem with me going to his house when he's not there to check on her. When I did lock the door, I got a message from him that told me not to lock the door because I don't know if he doesn't have a key or if he just doesn't bring it. There are numerous women in and out of the house. Sometimes as often as one will stay the night and the next day another one is there. He takes them to, and what he does with his personal life is fine. My concern is her safety being taken to other people's houses, or currently he has some lady there from out of state that I don't know how long he has known, but she is currently staying there this week.
Child's initial again is M, correct?
E,
E. Who is Mads?
Madison, our now adult daughter. I apologize.
Okay, because you
I
attached,
apologize. Yes, those were, I was hoping that she could attend with me to go over what those messages are about, but she has left the state.
you have, I believe you placed in your pleadings that the child on dad's time is not getting to school or getting pulled out of school.
Yes.
How often is this occurring?
It depends. I have dates when she has been, on December 16th, she was supposed to return from my parenting time. She did not. And at that time, Madison was living in the state and was at work. And I had to take her and drop her back off at Tony's house. And that is when I found out that he did not go to school and had been there babysitting
Babysitting who?
her younger siblings that are him and his estranged wives
Okay.
from another relationship.
At your home, excuse me, at your home, are you the only individual in the home other than your child?
No, my husband is there as well.
So the child's not left alone?
No.
Is a child of sufficient age, in your opinion, to be alone?
No,
Why do you say that?
she is not able to defend herself in case of, in my home, I apologize, sir. Would you mean in my home or?
In his home?
No.
Or even your home? Both?
I do not leave her alone unless it's for a short period of time. Plus I live next to my parents who she goes over there if I'm not home.
You live on the same street though as father, correct?
I do not.
No?
He lives in town of Owendale and I live out on Sebring Road.
Your pleadings that you filed indicates 7th Street address,
That is his address.
3571.
Yes,
Yours is 4518.
yes. Sebring Road.
You have 4518 7th Street, Owendale on your pleading.
Oh, no. I apologize.
So that's not your address?
No, it is 4518 Sebring Road.
Okay. The parenting time shows 7th Street. But then as I look, the custody
I
motion
so
shows
sorry.
Sebring Road.
Yes, I apologize. That is incorrect.
Okay. How far apart do you live from each other?
I think it is, I think 7 miles.
7 miles.
Yes.
How old are the children you're claiming your daughter is watching?
3 and 5. Actually, I believe 6 now. I believe she just had a birthday.
Okay. The problem is Mr. Hockmuth is not here, and I'm not sure why he's not here. And so what the court will do at this point well, what is it, before I make a decision, what is the proper cause or change in circumstance you believe the court should review the custody factors?
That she is left alone for numerous hours by herself. Well, left alone by herself for numerous hours after school. The amount of women that are in and out of the house. The fact that she is pulled from school to babysit and or has been pulled out of school or kept from school as a punishment because one of the nights that he had come home from work. She was not there. And he had called me to see if I had her, and I told him no. That I had seen her earlier in the day and that I was not sure where she was. I told him to go check around town. He told me he would not. And then she did end up returning home, but as punishment, she was kept from school to clean her room for that day.
Okay, this is what the court is going to do. I really need to have Mr. Hockmuth here, and it's his fault that he's not here, because it appears proper notice has been provided. If he's indeed working second shift, there'd be no reason at 10:42 he cannot be here at the courthouse. So on an interim basis, the court preserves the motions that you filed, custody and parenting time. The court is going to show cause the defendant, sua sponte, why he, and to explain why he failed to appear for today's hearing. And we'll set a date for that. And we'll see what happens with that. In the interim, though, I'm going to order two things. Number one, the child is not to be taken out of school during either parent's custodial time unless there's a doctor's slip explaining why the child cannot be in school. So if it's, well, you're supposed to babysit so-and-so. No, we need a doctor's slip. That's number one. So secondarily to that, child's how old again? 11?
Yeah.
The court will also order that both parents on an interim basis shall not leave the child alone unless there's a responsible adult with the child. So that applies to you as well. You understand that? I'm sorry, I didn't hear you.
Yes, Your Honor.
Okay, thank you. I'm applying to both parties because what's good for the goose is good for the gander. If the child shouldn't be left alone without dad being there, same applies with you. Now, if your spouse is there, great. That's appropriate. But I'm going to order that on an interim basis. We'll set a show cause date, and then we'll address your motions at that time. So we have assurances at this point. Number one, the child will not be left alone on either parent's time. And number two, the child's not going to be pulled out of school unless there's a doctor's slip explaining why. So we have at least a stopgap measure until we have the. Do you have any questions?
No.
All right, you're free to go. Thank you. In the file indicates to the court that Mr. Tucker is to be sentenced for domestic violence on the child on March 11th. Is that correct, sir?
Yes, sir.
Okay. As a result of that, at this point, I need to find out, the court needs to find out what happens at the sentencing. Specifically, is the defendant placed on probation? Is the defendant issued a fine? Is a defendant ordered to county jail time? I don't know that. And as that is hanging over the proverbial head of the court, we need to adjourn that proceeding. So we will not proceed on the parenting time matter today. That issue is preserved. After you've been sentenced, I will ask you, Mr. Tucker, to renotice this hearing. Do you know what I mean by renotice?
I do not.
Okay, this is not legal advice. All renoticing is to contact the county clerk to say, my motion was preserved, which I'm ordering today.
Okay.
And that you wish to have the hearing set on a particular Friday.
Okay.
And then notice obviously has to be provided to Ms. Marr, and then we can have our hearing on parenting time. Does that make sense?
Yes.
You understand it?
Yes.
Okay, thank you. So it's preserved. Let's talk about Ms. Marr's motion regarding, and you referred to it, Ms. Marr, in your documentation without the list as stuff, right?
Correct.
What are we talking about here?
Don't have it in front of me actually, but there was a list of stuff on there, that he had wanted, from his dad that was sentimental to him, that would help him with daily, like, it's sentimental to him, so it would help him having it.
Okay. And according to this, my son is asking for stuff his mama, Sarah, grandparents on her side, Sarah and my mom has gotten him. We're asking for stuff he has a special connection to. And you do have a list. So Nana blanket, Disney hoodie, Dogman books, necklace from wedding, John Deere hoodie, big Pikachu, Ohio State hoodie, Michigan fan.
My soon-to-be ex-wife's in Ohio, is from Ohio.
The enemy of your enemy is your friend, being a Spartan. So
Right.
Lion King back and a Pokemon hoodie, right?
Correct.
Okay. Tucker, what's your response to this?
To be honest with you, I did not bring any of that stuff with me because like like everything going on, my mind has been scattered, like we're trying to work, and
That's fine, but do you have any problem with providing these two?
some of the stuff I do, like the blanket and stuff like that, I don't have an issue with, but like the John Deere hoodie, I personally bought him for Christmas and I was kind of hoping to maybe just keep that at my house. The Disney hoodie, yes, his Nana did buy. I do not have an issue giving him that.
Okay, so let's go down the list then. You don't have any problem with the Nana blanket,
No,
Disney hoodie,
no.
Dogman books?
I have bought most of those for him for Christmas, and I would prefer to keep those at my house for when he does, if and when he does get to come back.
Okay. Necklace from wedding.
He can have that.
Okay. We talked about the John Deere hoodie, the big Pikachu.
I do believe I personally bought that myself too. But I mean, if it will help him, then yes, I will let him have it.
Okay. Ohio State hoodie,
He can have it.
Lion King book.
Like I said, I have to look through all of his books and look because he's got a lot of them.
And the Pokemon hoodie.
If it's the one I'm thinking of, it's a giant hoodie that zips up and it looks like Pikachu. If he wants it, yes, he can have it.
Okay, so everything except the Dogman books and
The John Deere hoodie.
the John Deere hoodie. Does that work for you, miss?
Yeah, that's fine.
So ordered. When can the property be transferred? Because I
Um,
believe there's a no contact provision in the Tuscola County case.
That has actually been lifted, lifted at my pre-trial. I didn't get a chance to come in with, like I said, with everything going on with trying to work and stuff like that. Tuscola County judge said that as long as I can have, or we can agree to have safe contact and visits with the child, then he has no issue with that.
Good, okay. How many days, when could you have this property to,
If she wants to meet me in Bay City tomorrow, if I don't have to work, I can have it to her tomorrow.
That's fine.
okay, by tomorrow?
And I will unblock her off my phone, so that way if something changes, I can let her know maybe Sunday.
That would be helpful. Do the parties communicate via app close?
I do not believe that app close is ordered for the parties. Historically, they haven't had a need for it. I think at this time. It would be beneficial.
Okay. You both familiar with that app close?
I still have it on my phone.
I sent him an invitation already, but I'm blocked, so. it didn't
Well,
go.
sounds like you're gonna get unblocked here. in a moment. I'll order the use of app close. That's how the parties are to communicate absent any emergency. So you can communicate back and forth with that regarding where you meet in Bay City, except for the Dogman books and the John Deere hoodie, as I understand it, the items will be returned. Or I shouldn't say necessarily returned, provided to Ms. Mar. Any questions, sir? Miss, any questions?
Is there still no visitation right now?
Right now, I'm maintaining the order that this court entered previously. Because sentencing is what, next week?
Next Wednesday, yes.
Yeah, next Wednesday. So after next Wednesday, let's see where we're at.
Okay.
And then if you have an idea what happened, sir, obviously you'll have the idea. But if it's probation or whatever the court may order absent county jail time, you can renotice this and we can, or if you have a mutual agreement to lift it, certainly you can present that to the friend of the court and the court can enter that if it's in the best interest of the child.
Yeah, I have my attorney that I had over there. She sent me the whole thing of everything that the judge said. I can, I'll just have to figure out how to print it out, or maybe I can forward it, email it.
Well,
I think he's referencing the Tuscola case. I have the bond conditions that are currently in place. I requested that from the court. I believe the misunderstanding is as it relates to the parenting.
I'm going to keep Well, wait a second. Yes, I'm going to maintain the order. Let's see what happens on March 11th. And then if the parties have an agreement that they want to have time, you could bring it to the front of the court. If neither party agrees, file the motion, which you've already done. We'll hear it then.
They wouldn't need to file a motion, Your Honor. I would just go forward with issuing a recommendation as has been ordered.
Okay, that's what we'll do.
Can I at least talk to him? Like, is there no contact order still in effect is what I'm asking. Like, if I unblock her, can she call me later when he gets from school and I can talk to him, or is that still?
Does that violate the order in Tuscola? It doesn't?
No,
Do
because
you have any objection to that?
I don't, as long as the child wants to talk, I have no problem with that.
I'll order that then.
I appreciate it.
Parties agree.
Can I add something else?
Sure.
I filed a motion, response to his motion. Can I just give him the copy of what I did, because his copy is in here?
Oh, yeah, you can provide that.
Okay.
Yeah, you can provide that to him.
It has medical information about the child in it too.
Okay, you acknowledge receipt of the documents, sir? That's the acknowledgement to me. Okay. Good luck to both of you.
Okay.
That'll be all, off the record. This is a show cause hearing filed against Ms. Montgomery, alleging violation of, well, I'll have the front of the court address that. Miss, would you please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God. Yes.
Thank you. Miss, your name is Cassandra Rose Montgomery?
Yes, Your Honor.
All right. From the front of the court, please. Ms. Schultz.
Your Honor, the parties last appeared before the court on January 6th. At that time, the court had already ordered the friend of the court to conduct an investigation into the issues of custody and parenting time. However, when the parties last appeared, neither party had submitted any documentation for consideration in the investigation. The court had subsequently ordered that they must complete their questionnaires and turn them into the friend of the court office by no later than January 10th at 4 p.m. Mr. Wilkos did submit his documentation. He is the moving party on the underlying motion. However, Ms. Montgomery did not turn in any documentation. It is my and so the show cause was filed, the matter set for hearing today. It's my understanding that the questionnaire was submitted this morning.
No later than January 10th. What is the interim order regarding parenting
On
time?
an interim basis, the minor child A, dad was granted physical custody, and Ms. Montgomery has parenting time 2 days per week. There is an underlying companion child as well.
Ms. Montgomery, why did you not submit the documentation by January 10th?
I moved to Macomb County, Your Honor, and I didn't have a way up here by the time that I had emailed the one paper that Ann had asked me to email her that copy. And then I did mail the rest, but it got returned to my brother-in-law's house, the one 25 River Road in Mount Clemens, where I was residing prior to getting my own house. It did get sent back there. So when I came to court to get Freya back, F, my other daughter, on February 21st, I did get another copy because they had said that they did not receive it.
Unfortunately, I don't find that as a proper excuse. When the court says January 10 at 4 p.m., it has to be filed by January 10. The reason for that is this child's in limbo. This child is in limbo, and the court has to make a decision based upon not only hearing testimony, hearing evidence, or seeing evidence, but also a recommendation from the friend of the court. And I've made it very clear at the previous hearing on January 7th that you needed to submit the documentation. You failed to do so. As a result, the court is going to continue the current order regarding parenting time in this matter, and I'm setting aside the referral for a friend of the court recommendation. You have to follow the rules. Prior orders will remain in effect relative to that issue. Ms. Schultz, do you have anything else? So again, if you want to file a motion to address parenting time or custody, you can do so, but I'm I'm putting the stop to this because I didn't get your documentation in time.
Absolutely.
Good luck to you guys.
Thank you.
Off the record. This is the defendant's motion alleging a violation of the judgment of divorce. Mr. Pomeranki is present. Court calls Elizabeth Howeson. A response matter scheduled for 9 a.m. It's currently 9:52. Mr. Pomeranki, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please state your name for the record.
David Michael Pomeranki?
Mr. Pomeranki, you filed this motion, correct?
Yes, sir.
And you filed it with the clerk of the court?
Yes, sir.
All right. Before we proceed on the motion, the court does not appreciate you telling court staff to shut up.
Who did I tell to shut up?
Court staff reported to me that you told court staff to shut up.
No, I did not. I did not say shut up to anyone.
Okay, well, do you need to call in the court employee to address that?
I guess if you'd like, because I didn't say anything to no one.
Okay.
I was talking to my significant other about other stuff.
Okay, stop.
I apologize, and I said I'm sorry. It's slipped out. It's human nature, and I apologize.
It's not human nature as far as the court's concerned. I have to restrain from using that language. You need to as well.
Yep.
You have an understanding. Please, even though you deny it, and I'm not here because I didn't see it, I didn't hear it, but it was reported to me. If you did it,
Any staff?
excuse me, sir. Don't do that, please. That's all I'm asking.
Yes, Your Honor.
Just be respectful. That's all I'm asking.
Yes, Your Honor.
Thank you. I appreciate it. You've alleged in your motion, Ms. Palmer and Ms. Howeson is not here, the window loan, that the window loan has not been paid. Is that correct?
Yes, Your Honor.
Okay. Do you have any records or anything to indicate the same?
Yes, I gave a copy to the court's clerk office of like everything that I've got from Foundation Finance.
Okay, and that's dated January 27th, 2025?
Yes.
Okay, it's in the court record then.
Yes.
Also,
I have in there a copy of our judgment of divorce
and the court reviewed that.
Yep.
Now, it appears that this has not been paid since 2021.
Correct, Your Honor. I was the last one to make a payment on it on 9/21 before I was incarcerated when she had taken over the house. And she was supposed to take over the payments. And then the judgment of divorce was ordered in 23. And that was over a year and some change ago, and she still has not made a payment. And Foundation has called me and can't get a hold of Ms. Howeson. And I'm deemed indemnified and not held responsible for it, and it's ruining my credit.
What are you requesting of the court then, sir?
I talked to Foundation Finance. It says right here, the payoff amount is $11,956.08. That's what they want in order to get my name off the loan. And I don't know what else to do in this matter because it says in the order she was supposed to pay it and she has not paid it.
Okay. What the court is going to do, Mr. Pomeranki, is issue a show cause for her, which means that she'll be required to come into this courtroom. She should have been here today.
Nothing's gonna happen about that for her not showing up.
Well,
That's a contempt.
at this point in time, I need to have the information for the show cause could be a contempt, but I have to show cause her first.
Okay.
I'll show cause her. The court sua sponte on its own initiative will show cause Ms. Howeson. She must appear at the next court hearing and she could be held in contempt at that hearing.
Okay.
I can't proceed on contempt at this point until I hear from her. But in the meantime, I will require her appearance at a future hearing, which will be sooner than later.
Okay.
Any questions, sir?
No, that's it.
All right. Thank you. This is the plaintiff's motion regarding parenting time. The parties are present. Ms. Viginski appears via the Zoom application. Mr. Viginski is in the courtroom. And we also have on our Zoom screen, Gina Shemansky, which we'll address in a bit. Will all three individuals please raise their right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. You may put your hands down. And this hearing, the court advised that the parties and witness could appear via Zoom based upon the potential of witness testimony the witness being unavailable to appear in the courtroom. And so we will proceed accordingly. Before we proceed though, again, just to stress to everyone, please do not use the child's name. You can use the child's initial if you wish. That's it. Don't use the child's name, and we'll proceed. So Ms. Vajinski, do you wish to call your witness at this time?
Yes, I do. I would like Gina, who is W's therapist, to give her statement on why it's appropriate or why it's important for Wyatt to have his dog with him when he goes to his, goes to his father's.
All right. Miss, would you please state your first and last name, spelling both for the record, please?
Yep, it's Gina, Jeana. And I apologize. My married name is Burkhart, Burkhard.
Thank you. Ms. Vajinski, you may question your witness. Go ahead.
In terms of your past therapy sessions with W, how has he been feeling or stating, what has he stated about his dog?
So I believe it was early January that it was brought to my attention that the dog can't come to dad's anymore. He broke down in session. He became really tearful and withdrawn and was visibly upset about this. This is a kiddo who has some anxiety. He worries a lot. I think the dog gives him a sense of comfort, security, safety in a world that he can't control. Like when kids kids of divorced families, they don't have a lot that they can control. And I feel like that gives him a sense of safety having his dog with him.
Do you feel as though it is important for his dog to travel with him back and forth like previously arranged up until the January dates with his father?
Yeah, absolutely.
Do you think it helps his emotional and mental well-being, having his dog as a support for him?
Yes, I do.
So are you recommending that his dog continue to travel back and forth with him as previously up until January?
Yes, I am.
I have no further questions.
Thank you. Mr. Vajinski, do you have any questions of the witness?
I do. So previously we had spoken and you had stated that you would support whatever the parents' decision was regarding the dog and that it was, in your opinion, not needed for the animal to travel with him. So is there a change in your evaluation on this?
I don't think that's exactly what I communicated. I think that W would be very resistant if this changed, and he would potentially refuse to go to parents' house. And I support the parents in whatever decision they make. But am I going to advocate that that bringing the dog with him benefits his mental health? Yes. But I can't tell the parents what to do. Like, I can't tell you how to parent or how not to parent.
Okay, now it would benefit him, but in your opinion, is it a necessity?
I feel like in the position we're in, like now deciding after a few years taking the dog away, I think is going to be detrimental to his mental health.
And have you seen a change? It's been over 2 months since the animal has not traveled. Have you seen a change in his behavior or in regards?
So this is something that's brought up pretty much every time we see each other. Now I haven't seen him, and that is because of my own scheduling things, but it has been about a month since I've seen him.
He's scheduled to go next week, but
Yeah. Mr. Vajinski's asking the questions at this time. You'll have an opportunity to ask more. Go ahead.
Okay.
At this time, I don't think I have any more questions.
Nothing else? Okay. Ms. Vajinski, you can finish up your question.
I'm sorry, it was just a statement that he did have a session scheduled, but like Gina said, that it did have to get canceled due to a family emergency on her behalf. He does go on Tuesday next week.
I just have a question then. Ms. Burkhart,
Mhm.
this is your recommendation, correct?
Yes, I'm encouraging the court to consider his mental health. Yes.
Okay, thank you. Ms. Vichinsky, any further proofs you wish to present?
No, I mean, I just have the letter that Gina had written, but she pretty much testified everything that was in her letter. I just would hope the court consider, I mean, W talks about this on the daily pretty much with me. It's never really been addressed with his father. And from, it's all hearsay what W has said, but I definitely see his mental health suffering. That is his support, that is his constant. And when he was going with him to his father's house and I would talk to him, you know, there would be numerous times that he'd be like, I'm just in my room with Trigger. The dog's name is Trigger. And I understand that Aaron will state that he doesn't take care of him the best, but I think like any 12-year-old, I don't think that, you know, necessarily they take care of things like you and I do. So I just would hope that you would consider, as it is definitely weighing on his mental health. And matter of fact, I'm actually going to talk to Gina potentially about increasing his therapy back to weekly because I have noticed a tremendous change lately.
Mr. Vichinsky, do you wish to present any proofs or just argument?
Since the first of the year when the animals stopped coming, I haven't seen any negative effects on Wyatt at my home.
Please use the initials.
Yes, sorry. So, and when previously when the animal was in my home, it doesn't seem like he needs it. He kind of ignores them for the most part. Like there's not a whole lot of interaction. Maybe it's a comfort thing just to have him there, but there's not really an interaction with the animal. It's very occasional, excuse me, while he's there. So that's just my perspective.
All right, thank you. All right, the court has considered the testimony. The court has read the motion filed and the response in this matter. The parties have joint legal custody, and I believe it's alternate weekends, sir, that you have. Sure. And there was mention in the motion regarding some sort of verbal agreement where one party took some animals and the other party took the other animals, and there's a reported agreement regarding how that was going to work. And sounds like it was a verbal agreement, but that's not a court order, so obviously the court cannot enforce that. This sounds like an issue of best interests of the child when it pertains to his mental health. And essentially what is being requested is that the animal be with father when it's father's parenting time. And when it comes to ordering something like that, that's not within the province of the court. Certainly if it's removal of a barrier or an issue, such as an individual who may be a predator, sex offender, things like that, that may be a different story. So I cannot grant the motion to force father to take the dog. However, I will say this. The best interest of the child, at least according to the testimony I heard from Ms. Burkhart, indicates that the child is better or in a better mental state when the dog is there. Now, maybe the child doesn't interact with the dog as father thinks the child should, or yeah, as the child should, and that this is some sort of different idea or different ulterior motive. I'm not sure what it is, but the court will state this for the record. If the mental health of the child is bettered by the animal being with the child during dad's time, it would stand to reason, common sense, that the animal should be with the child on dad's time. However, I can't force a parent to take an animal. I can't. That's not within the province of the court. However, as I stated, if it's in the child's best interest that the animal be there, that would be a good sign that, you know what, maybe I should just have the dog and be done with it. That's how the court looks at it. I won't order it specifically, but I strongly recommend it. That's all I can say. And at the end of the day, certainly, if there's a motion for custody or a motion for modification of parenting time, and there are allegations of mental health issues regarding the child, this is something the court could consider to modify parenting time and or custody. And I don't want to do that, clearly. So I strongly encourage Dad. I know it may be a pain in the you-know-what regarding the animal, because I believe you have the cats, she has the dog. It may be uncomfortable, it may be a hindrance, it may be a bother, but if it helps the child, I would strongly suggest you follow through. That's all I can say. So I respectfully deny the motion, but I strongly encourage Dad to do the right thing. That is my ruling. That'll conclude the proceedings. Thank you, everyone.
Thank you.
Or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
I do. Thank you. Mr. Holdwick, what's the status of this matter, please?
Your Honor, this was brought before the court for a show cause regarding non-payment of support. This case is a little different, as the court is aware. We do receive withholding orders for Mr. Bebeszewski. However, it is the monthly withholdings are only about half amount of what the support order states. The file in this case says Mr. Bebeszewski has been instructed he had to make additional payments with his other income that is not garnishable to try to meet that obligation.
What is the other employment? Okay.
And it looks like on the account, Your Honor, we've been receiving about $546 a month on a monthly obligation of $1,095. Back in June, the court had ordered, I believe, a bond from Mr. Bebeszewski in about $7,000, a little over, to secure payments for future monthly obligations. That was posted in June, and then since then, there have not been any additional payments besides the disability withholding. So the motion was brought back before the court. This has been an ongoing issue. Mr. Bebeszewski reached out to me, I believe, yesterday, stating that the parties have worked out some type of an agreement or are on the same page of payments moving forward. I'm not 100% sure. And it was stated that could be stated on the record today. So I'll defer to the parties on that.
All right, but is the bond still out there?
The bond has been posted. It was paid and posted on the account.
The bond was secured for payment of future support payments. However, Mr. Bebeszewski authorized the release and application of the full bond amount for
Oh, so it's already been applied. Okay,
And
got it.
currently, the case, Your Honor, has an arrears of $14,919.
Has the AG's office been notified on it?
I believe they have been in the past, but my understanding is they are not authorizing or following through as monthly payments are coming in.
I see. Okay. Pretty big amount. Pardon me?
And the other-
I also made a payment today, Your Honor.
Yeah, I'm sorry. There was I believe, a $600 payment that was made this morning before court.
Okay. Okay. Well, we still have huge arrearage here. Mr. Holdwick stated, though, Mr. Bebeszewski, that there may be some agreement between you and Ms. Kettle. Is that correct? Okay. What do you believe the agreement to be?
Well, I just went through another divorce. I had a number of things that was divided, if you will. I talked to Ms. Kettle about it. We've been on the same page for several months. Now that everything's taken care of, we have an agreement that everything within the first 7 days of the month paid full obligation.
The arrearage?
Well, the arrears, but it would be the payment plus additional to knock down the arrears.
So 1095 and more money to be paid?
Additional, yes, sir.
How much are you proposing per month?
At least a couple hundred each, every other week.
So for the month, though, you're talking at, when you say couple hundred,
300-400, I would assume would be something that's doable, Your Honor.
$300 to $400. So it'd be at least $1395 or $1495 per month.
Yes.
When would you start making that payment?
beginning of next month. I could probably, within another 2 weeks, make another payment. Start knocking it down faster. That way the arrearages aren't existent.
Mr. Holbrook?
Just for the court's information, so far for the month of March, we received $556.50. With the addition of the 600 that was paid today, his monthly obligation will be met.
Satisfied.
So any further payments this month will just go straight to the arrears.
Perfect. Well, that's good for March.
I'm still gonna make an additional though, Your Honor, you know.
I appreciate that because it's for the child. That's what it all comes
Yeah,
down.
we've been on the same page about extracurriculars. I put money to her as well, paying for extracurriculars and clothing and whatnot.
Okay. Ms. Kettle, do you agree with this?
I just want to make sure that we have a date, like he makes his normal payment like first of the month and the second, like 2 weeks later, he makes the additional payment. If we can get something a little concrete, that way he can follow that, I think that would be doable.
What do you say to that, sir?
I'm fine with that.
So half of it,
By the 14th, the second one needs to be made, I guess? Does that sound fair?
and the second at the end of the month?
Sure, that sounds fair to me.
Well, I'm asking, is that what you're proposing?
Yeah, that's fine, Your Honor.
So the midpoint of each month, and then by the end of the month, we would have at least $13.95 in
Right.
support.
Yeah, that's correct.
Does that work for you, Miss?
It does, because of the history, what do we do if that does not get met? We just meet back here again?
You can let the friend of the court know and they can show cause the matter.
If the court approves, we could do a status conference on Friday, 90 days out to see for compliance.
Do a review in 90 days.
Absolutely.
All right. So both parties agree with this?
Yeah.
Sure. Oh, look, you good with this?
So just so I'm clear, Your Honor, it's the already withholding order of the 556 that comes at the beginning of the month. And then Mr. Bebeszewski would have until the 14th to make an additional payment. And then by the end of the month, another additional payment? Is that
Yes.
how I'm understanding this?
Yes. So whatever the withholding is, and then you add to that by the 14th, at least half of the support obligation. And at the end of the month, the rest of the half, which would total at least $13.95. That's the total amount per month that he's going to be paying at a minimum, $13.95. His current obligation's $10.95. He said $300 to $400 per month.
And the first day of the month, we already received over half the court obligation with the current withholding.
Okay.
So in addition, you just want half of the $13.95 by the mid-month.
Yes.
Okay.
Yes. Fair?
Yes, sir. Would it help if I call when I make or provide a copy to Ms. Schultz or Mr. Holbrook?
I think they'll see it in the system. Do you wish to?
Normally, when the payments are made directly through the state disbursement unit, we can usually see that information within 48 hours. If you want to email us and let us know you posted it, we can keep an eye on the account to make sure it comes through.
Do that.
We're all good? So, Miss, do you agree that things have been better regarding communication?
Communication between the two of us has been great since the last few months, yeah.
I love to hear it. That's great news. Let's keep it up. We'll see you in 90 days. You'll set that up, Mr. Holbrook?
Yes, you are.
Okay. You're all free to go.
Appreciate it.
Off the record. Proceedings relative to a domestic relations matter. Mr. Camps is present. He's in pro se. However, he is a licensed attorney, P number 68561. Court calls Ms. Torres. No response. I have a question, though, regarding the default in this matter, because there was a request for default and request an entry. That request was done on December 19, 2024. The default entry was entered on December 27th, but it says certificate of mailing on December 23rd. So how could the default have been sent on the 23rd when it wasn't even entered until the 27th?
Judges, I do have a copy of the default and request of entry. It looks like what happened is that my legal secretary sent it a certificate of mailing on the 23rd, and then that the family court clerk also mailed it on 12/27/2024.
And so it would appear to me that the court clerk entered it that same day, 12/27/2024. So it would appear that it was sent twice, once by our office, and then there's also an amended or an additional signature of the family court clerk that it was sent on 12/27/2024. I do have a copy of that certificate of mailing if you would like me to approach with the judge.
You're an officer of the court, sir.
Yes, sir.
You're an officer of the court. So if you say it and it's there, it's there. So we can proceed.
Thank you, Judge.
You're welcome. And you may be seated, sir. Would you please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
I do.
Sir, please state your name for the record.
Peter Camps.
Mr. Camps, you're the plaintiff in this matter, correct?
I am.
You are also a licensed attorney?
I am.
Do you practice in domestic relations matters?
I do not, Judge.
Okay, we'll walk it through then. Have you lived in the county of Huron at least 10 days, in the state of Michigan at least 180 days immediately preceding your filing this complaint for divorce?
Yes, Judge.
At the time you filed this complaint for divorce, was Ms. Torres a resident of Huron County, or was she a resident of Orange County, Florida?
At that point, she was not residing in Huron County. She was residing in Orlando, Florida, where she has been for at least 2 years.
All right. And is it true that you were married on January 14th, 2019 in Jamaica by a person authorized to perform marriages there?
Yes, Judge.
And the parties have always maintained the same names as I've recited just a few moments ago, correct?
Yes, Judge.
And are there any minor children of this marriage?
No, Judge.
And as far as you know, is a defendant currently expected?
No, Judge.
You've alleged in your complaint for divorce that there's been a breakdown in the marriage relationship to the extent the objects of matrimony have been destroyed, and there remains no reasonable likelihood the marriage could be preserved. Was that true at the time you filed the complaint?
Yes, Judge.
Still true today?
Yes, Judge.
Briefly, in your own words, can you state to the court why you feel the marriage cannot be preserved?
There's been a marital breakdown, and there is no chance of reconciliation at this point.
All right, you answered one of my questions. But if the court did not grant you an absolute judgment of divorce today, would you be willing to resume a husband-wife relationship with the defendant?
No.
All right. Do you have a proposed judgment?
I do, Judge.
Would you please present that to the court?
Yes. May I approach?
Yes, you may, please.
I do have 3 copies of
That's fine.
proposal.
Thank you. You may be seated, sir. Your proposed judgment indicates that neither party would be awarded spousal support and the issue is forever barred, correct?
Yes, Judge.
And as it pertains to any beneficiary rights, any rights either party has to the proceeds of other benefits and any policy of contract of life. Okay, so basically anything relative to life insurance, carrying any cash value, retirement income, pensions, annuities, retirements, each party would receive that free and clear from any claim of the other, correct?
Yes, Judge.
And you already addressed retirement accounts, and there's profit sharing as well. I see here listed retirement accounts, statutory pension, and profit share. So if there are any profit sharing issues, each party be receiving whatever profit sharing is in their respective.
Correct, Judge.
Okay. Each party be awarded the personal property currently in their possession, free and clear from any claim of the other.
Yes, Judge.
If there's any debt owing on that property, the person receiving the property assumes the debt. The other parties held harmless and indemnified therefrom.
Yes, Judge.
Do you own any land?
I own a home, Judge. Yes.
Oh, each party be awarded the real property currently in their name and possession, free and clear from any claim of the other.
Yes, Judge.
And does the home have both names on the deed or just one?
Just myself, Judge.
Okay. Each party be responsible for the debts in their respective names.
Yes, Judge.
Surviving spouse rights would be extinguished as to both parties.
Yes, Judge.
Regarding the property that I mentioned ago, are you holding any property of hers or is she holding any property of yours?
None, Judge.
Any other marital debts or assets that you're aware of that we've not addressed?
No, Judge.
Thank you. Based upon the testimony presented, the court finds that the statutory grounds for divorce have been established. Therefore, a judgment of absolute divorce is granted to the plaintiff, Peter N. Camps, from the defendant, Andrea Alejandra Plaza Torres. I make a finding there are no minor children parties. Neither party is awarded spousal support. And I maybe I failed to ask that. Neither party would be receiving spousal support.
That's correct, Judge. Thank you.
All right. Court will order that. The divorce judgment shall include the property division as outlined on the record, as well as any and all provisions concerning pensions, life insurance as well, and all other provisions contained within the judgment. Court will execute the judgment that has been presented in this matter. And Mr. Camp, what will happen next is I will give you the judgments. You can take those to the clerk's office, which is right around the corner there. And the staff will get those processed. You'll be able to get your true copies today.
Very good. Thank you.
Any
Judge.
questions?
I have no questions, Judge. Thank you.
All right, thank you. If you want to just have a seat back there, and as soon as I finish this, we'll hand you the documents or ask you to approach, and then you'll be all set.
Very good. Thank you, Judge.
You're welcome. Off.